Between 1906 and 1920, a remarkably compact network of organizations, American Jewish Committee, NAACP, with decisive Jewish co-founding and early leadership, Anti-Defamation League, American Jewish Congress, and American Civil Liberties Union, emerged in New York and Chicago. Within a single generation, this network had positioned itself as the indispensable drafter, interpreter, and enforcer of the legal framework that would eventually govern discrimination, hate speech, education, and employment across the entire United States. The Southern Poverty Law Center, founded in 1971, later joined and amplified the same model. What began as a coordinated response to quotas, lynchings, and defamation has, over 12 decades, matured into the dominant apparatus that writes the statutes, supplies the authoritative definitions, trains the enforcers, and litigates the test cases that continually expand the regime's reach. The mechanism is elegant in its simplicity and ruthless in its consistency. A statute is drafted with broad, morally unimpeachable language. No discrimination on the basis of race, religion, or national origin. Penalty enhancement for bias-motivated crimes. Hostile educational environment. Passage is secured through coalition politics and appeals to universal justice. Once enacted, the statutory gaps are filled by the same organizations through compliance guides, annual audits, law enforcement trainings, and carefully chosen litigation. A vague clause becomes a binding regulation. A regulation becomes a precedent becomes an irreversible norm. Each cycle widens the circle of protected conduct and narrows the zone of permissible dissent. The pattern is visible from the very first campaigns. The fight against the 1917 literacy test and the 1921 to 1924 national origins quota system was not merely about humanitarian relief. It was about who possesses the authority to define the legal category of the acceptable American. When those battles were lost in Congress, the network shifted to administrative exemptions, diplomatic channels, and the slow accumulation of case law that rendered restrictive definitions vulnerable to challenge. The conceptual victory, establishing that certain classifications are inherently discriminatory, was carried forward into the 1950s and 1960s, where the same playbook dismantled Jim Crow and produced the Civil Rights Act and Voting Rights Act. The terminology migrated. National origins became protected characteristic. Undesirable alien became hostile environment. By the 1980s, the focus had shifted to sentence enhancements and data collection mandates. The ADL's model hate crime statutes, adopted by 46 states, required law enforcement to record and investigate bias motivation using categories and training materials supplied by the ADL itself. The SBLC's hate map, launched in 1990, performed the same function for private sector enforcement, a designation that carries no formal legal weight yet determines access to payment processors, charity platforms, and public venues. The ACLU and NAACP-LDF, meanwhile, secured the expansion of disparate impact liability and hostile environment standards under Titles 6, 7, and 9, standards that rely on interpretive frameworks developed and disseminated by the very same network. The ratchet turns in only one direction. When courts occasionally narrow an interpretation, Shelby County v. Holder, 2013, on voting rights, the 2024 to 2025 Title IX rulings limiting Dear Colleague guidance, the response is not retrenchment but renewed legislative and administrative pressure to close loopholes and restore protections. Each setback supplies the moral urgency for the next advance. The IHRA working definition of anti-Semitism, drafted by a small group of scholars and adopted by the ADL, became federal executive guidance in 2019, state law in dozens of jurisdictions by 2025, and the basis for hundreds of university investigations, transforming a non-binding document into a de facto speech code enforced by the Department of Education. This is not contrived conspiracy theory. It is the ordinary operation of a highly effective, ideologically coherent advocacy cluster that has maintained continuity of personnel, funding, and strategic vision for over a century. The same families, law firms, and communal institutions that mobilized against the 1924 Immigration Act supplied the lawyers who wrote the 1964 Civil Rights Act, the experts who defined hate crime in the 1980s, 1990s, and the organizations that train corporations and campuses on bias incident reporting. The goals announced in 1906 to 1920 open pathways for so-called persecuted minorities and legal defamation, secure equal treatment, have never been abandoned. They have been universalized, refined, and institutionalized to the point where the network now supplies the operative meaning of discrimination itself. The result is a regime in which the drafters of the law remain its primary interpreters and enforcers. A statute that began as a shield against overt bigotry has become a finely calibrated instrument capable of reclassifying centuries-old symbols, political criticism, and private employment decisions as actionable bias. The feedback loop is complete. The organizations that write the rules measure compliance with their own metrics, litigate deviations from their preferred outcomes, and return to the legislature when judicial or political resistance appears. What originated as a minority defense strategy has, through persistence and skill, become the dominant regulatory framework governing speech and association for 330 million Americans. The hand on the lever has changed little in a century. The architecture erected by the 1906 to 1920 Advocacy cluster represents not a mere historical artifact, but a meticulously engineered machine of perpetual subversion, designed from inception to grant its creators an unassailable advantage in defining and enforcing America's social order. This network, comprising the AJC, ADL, AJ Congress, ACLU, and NAACP with its embedded Jewish leadership, later augmented by the SPLC, did not merely respond to injustices. It proactively seized upon them to construct a self-reinforcing regime where vague moral imperatives are transformed into ironclad controls over discourse, opportunity, and identity. The elegance lies in its ratchet design. Each legislative advance, from the Civil Rights Act's broad prohibitions to hate crime enhancements, embeds interpretive ambiguities that the same entities exploit through trainings, audits, and litigation, ensuring expansion without retreat. What originated as campaigns against immigration quotas in the 1920s, reframing sovereign borders as discriminatory barriers, evolved into the conceptual subversion of all distinctions, where national origins morphed into protected characteristics that now police every facet of public and private life. This mechanism's ruthlessness manifests in its unyielding forward motion. Setbacks, such as the 2013 Shelby County ruling eviscerating Voting Rights Act preclearance, or the 2025 federal vacatur of Biden's Title IX expansions on transgender protections, are not defeats but pretexts for renewed offensives. The network responds by demanding restorations that invariably broaden scope, leveraging media alliances and coalition facades to brand resistance as bigotry. The IHRA anti-Semitism definition, propelled from a 2016 guideline to federal guidance in 2019 and enshrined in dozens of state laws by 2025, including New York's Executive Order 52 and Columbia University's formal adoption, exemplifies this. A tool for reclassifying political critique as hate, enforced through investigations and deplatforming, all under the network's interpretive monopoly. Continuity of vision, sustained by intergenerational ties and families, firms, and institutions, ensures that the same architects who undermined 1924 quotas now arbitrate today's bias incidents, turning advocacy into quasi-sovereign authority. Ultimately, this regime embodies the triumph of strategic subversion. A minority cluster, leveraging grievances as leverage, has embedded a one-way valve in American jurisprudence where protections perpetually inflate, dissent contracts, and the originators retain veto over meanings. The victory is conceptual and absolute. Control the frame of discrimination, and you dictate the nation's boundaries of thought and action. What masquerades as justice is, in essence, a permanent apparatus for dominance, resistant to democratic reversal and engineered to endure indefinitely.
you.